Okay, good morning everyone and welcome to our online webinar on COVID-19, Labour Law for Businesses Employees, Part 1. My name is Sarah Haffenden and I'm the Marketing Communications Manager at UKZN Extended Learning, also known as UEL. So in case you are unfamiliar with UEL, we are the continuing education unit of the University of KwaZulu-Natal and we offer all the short courses on behalf of the university. So why are we offering these webinars? So we at UEL are in full support and compliance with President Cyril Ramaphosa's directive of a national lockdown issued to address the COVID-19 pandemic. So we are also embracing the changes and are working on a number of projects aimed at providing free access to learning materials during this lockdown period. One of these projects is our online learning webinars. So this webinar in our Learning Lockdown Initiative is a 4-part series focusing on labour law issues relating to COVID-19. We've also already launched a series on the changing world and the 4th Industrial Revolution, and that takes place every Thursday throughout April. But please do take a look at the final slide at the end of this webinar for further details on our upcoming webinars, or you could visit our website www.ukznextendedlearning.com. So I would now like to introduce you to our guest speaker for today, Dr. Tamara Cohen. Tamara is a former Associate Professor of Labour Law in the School of Law at UKZN and currently an Honorary Research Fellow at UKZN. She is an experienced labour law trainer and facilitator, a panelist of Equitate Professional Employment Law Solutions, specialising in labour matters, an accredited commercial mediator, and an admitted attorney. She has co-authored various labour law texts, including Labour Law Through the Cases, Labour Relations Law, Trade Unions and the Law, Labour Law in Context, and Laws Against Strikes, Strikes and the Law, and Labour Law, amongst others. Tamara has published many articles in the field of labour law in leading law journals and has presented conference papers both nationally and internationally. So Tamara has facilitated many workshops on various aspects of labour law, and this is her first webinar that she's doing with us today. So we wish her all the luck. So please join me in welcoming Tammy. Over to you, Tammy.
Thank you. Well, I do feel like this is unknown territory. I am sitting here with no shoes on, which I never normally do in meetings. But anyway, let me have a bash at this. Okay, so this is a very controversial area for, obviously, this is uncharted territory. Our life as we know it has absolutely changed. And from a labour law perspective, there's a massive amount of uncertainty as to the responsibilities and duties of employers and employees during this COVID-19 period, during lockdown and beyond. I've been asked by UEL to address some of the main issues that employers and employees are facing during this period. Some of what I'm going to tell you about is hard and fast law. There have been amendments, there have been regulations issued, so it's not speculation on my part. But to a degree, I also am going to and have to speculate as to the impact and effect of these changes and as to the application of our existing labour law to this very unique situation. Well, just as an intro, as we all know, from the 26th of March, many businesses have had to close their doors other than essential services. For those lucky enough to be able to continue working remotely, they have been able to generate some kind of income, albeit probably a reduced income and with challenges of their own. But for many businesses, they've literally had to shut their doors and send their employees home for 5 weeks. Obviously, the financial implications of this are going to be catastrophic, particularly for small and medium enterprises. That might, in fact, be the end of the road for many of these businesses. I'm going to use this week and next Tuesday, where I'll come back again and talk about, again, employers' obligations during this period, to talk about a number of issues. I'm just going to briefly take you through what I am going to cover. Only some of this I'm going to get through today, and the rest I'll get through next week. First of all, and this is the big hot topic, is whether employers are obliged to pay employees. There's a lot of controversy. Can employers quite legitimately stop paying employees altogether? Does the work no pay rule apply in a situation like this when it's really out of the hands of employers and employees whether to continue operations? And then a big topic that I've thought about very long and hard this weekend is what about benefits? If an employer is not paying if they're not paying a remuneration to their employees, are they then obliged to continue paying medical aid contributions, provident fund, pension fund contributions? Because clearly, if that is not paid, the implication is going to be huge. If a medical aid contribution is not paid, for instance, it is very conceivable that that member employee is going to find themselves completely out of funds, out of cover at the end of the day. So I'm going to talk briefly about that. I'm going to spend a lot of time this in now half an hour talking about the new UIF temporary employee relief scheme. I'm going to also look at whether employees can be forced to take their annual leave, and whether once that annual leave has run out, whether that can be then extended to unpaid leave and possibly even negative leave going into essentially eating into next year's leave. I'm going to also briefly talk about self-quarantine. Can that be then regarded as sick leave, and does that then apply during the lockdown period? Because self-quarantine is again covered by the Unemployment Insurance Fund, but only when it really is classified as sick leave. Another topic area that I've been asked on many occasions by employers recently is, can an employee be put on short time or temporary layoff, which really falls under the area of retrenchments, and what procedures would then apply in that situation? Next week, I'll only get to essential service employees. Can they actually be forced to work, and would a refusal to work constitute insubordination? Many essential service employees feel that their lives are in danger. They run the risk of taking the virus home to their family members, and many have indicated an unwillingness to work. So what are the implications of that? And then finally, again, I'll only deal with this next week. What are the obligations of an employer from a health and safety perspective after the lockdown and beyond? It doesn't mean once every employee goes back to work that the obligations of employers come to a screeching halt. So just to start, and I'm sorry, the lawyer in me has insisted that I do tell you a little bit about legal principles that apply in this situation. But there is this principle, it's a common law principle known as supervening impossibility of performance. And what this really means is that parties are effectively excused from performing their contractual obligations due to events beyond their control and foreseeable expectations. And this, in my mind, is a very classic example of this situation arising. Now, this termination or suspension of contractual obligations obviously doesn't only apply in the employment context, but applies to every contract that is essentially affected by COVID-19 in a way that it becomes impossible to perform. So my next bullet point just explains that the performance, it's no good to say, well, we can't perform the terms of our contract, but we are working remotely. The performance must be objectively or absolutely impossible to perform. And obviously, objective impossibility doesn't only apply to actual physical impossibility, but it also applies to a situation where performance becomes so difficult and so unrealistic that it cannot reasonably be expected to be performed. And I think, again, a situation like this it's conceivable, it's possible that businesses may continue to perform remotely, but it's not necessarily possible that they can actually do the business that they are tasked to do. And then another area of supervening impossibility, and this I think is the particularly applicable one, is that it's referred to as supervening illegality of performance. And this arises where performance, although factually possible, becomes prohibited by a public authority. And in my mind, the lockdown, the government directive, and that lockdown creates an illegality for businesses to continue. And what it means is this supervening impossibility means that the contract cannot be performed. It is either suspended or terminated as a result of this impossibility. And this is the reason why I can tell you with absolute certainty that employers are not obliged to pay their employees. Obviously, from a moral perspective, obviously employers are encouraged where possible to make even partial payment or full payment, but from a legal perspective, they are absolutely not obliged to make payment, and the well-known maxim of no work, no pay would apply in that situation. Some businesses, and maybe this is something to think about for the future, would, what we now have learned, the benefit of hindsight, to maybe include contractual provisions in all of your contracts with suppliers or clients, is to include a contractual provision in your contracts, which is called a force majeure provision that essentially caters for an act of God or an unknown impossibility, but actually placed in contract, so nothing will be left to doubt in a situation. Obviously, employees that are working remotely, whether it be part-time or full-time, are entitled to be paid. And if they are working only on part-time, a few hours a day, they would only be entitled to be paid pro rata. But obviously there is an obligation in that situation because there is work, so there is an entitlement to pay. As far as the pension or provident fund issue, which I've alluded to briefly, as I've said, this raises a very, very topical issue and also places the employee and the employer in a very difficult situation as far as contributions to these funds, many of which has very, very harmful impact on employees that are no longer that are effectively in breach of their pension and provident fund requirements, and obviously in breach of their medical aid contributions. But unfortunately, what I've discovered through my research is that there is, well, perhaps fortunately for employers, is that there's no obligation on an employer to continue to pay these contributions during the period that they're not paying remuneration. There have been directives that have come out from the various sectors. There's been the, I just want to get the exact terminology right for you. Sorry, there's been the financial sector that deals with pension and provident funds. And then there's also been the medical schemes sector that have both come out and encouraged the funds and encouraged the various medical schemes to try and be flexible and to try and make allowance in these situations. And in actual fact, they've given it a communication. They've called it a communication that's certainly not of lawful standing to pension funds to try and suspend the obligation to pay contributions where at all possible over this period. But as it stands, there is no obligation on employers to pay these contributions at this point in time. And then obviously from, as you well know, essential service employees are obliged to continue working, and despite any kind of financial difficulties faced by their employers, they are entitled to full pay in these circumstances. We will have an opportunity at the end for some questions and answers. I'm sure that you probably would like a little bit more information on some of these aspects, but we do have time at the end to get to them. Okay, well, I'll tell you about, I'm going to tell you about this TERS scheme. I'm sure a lot of you have heard about it. It's the C19 Temporary Employee Relief Scheme. It was gazetted on the 26th of March. And most recently was amended on the 6th of April to try and provide some clarity as to what the real application of the scheme is. Just as just to mention that the government has set aside at this stage 30 billion rand, that's billion, not million, and I think they will use every cent of it to fund the scheme. It's going to be administered through the Unemployment Insurance Fund that is going to be hit by a steam train when they are having to administer this at its full capacity. There are already over tens of thousands of applications that have been put in for subsidy through the scheme, and first tranche of payments will be coming out this week. So it will be a good test, a good litmus test to see how effective and how capable the Unemployment Insurance Fund will be of dealing with the situation. This scheme applies to employers that have had to close their operations entirely or in part. At first, there was a lot of debate about whether it also referred to in part. But yes, if a particular division of an employer's workforce has had to close down, even if certain employees, admin staff have had to stop being paid, have no work to do, this provision still applies. The company will still qualify for this temporary relief benefit. The benefit itself only pays a proportion, actually. It's not a full amount of the cost of the salary of the employee during the temporary close down. Obviously, in that situation, it needs to be established that the employees are not being paid during that time, and I will come back to that because there are slight amendments to that. I'm just keeping an eye on the time. Some of the requirements, and these are trite, is that the employer must have been employing that employee on the 27th of March when shutdown began, and there has to be a loss of income in that regard. Now, there was also a lot of controversy about exactly how much employees would be entitled to be subsidized, because the Act originally said, with the amendments originally said, that salary benefits were going to be capped at a maximum amount of 17,712 Rand, and everybody sort of rubbed their hands in glee thinking that is the maximum amount that could be paid out. That's not in fact correct. That is the base salary that the calculations will be made against, and will be calculated against what is referred to as an income replacement rate sliding scale. So depending on how high the salary is, employees will be entitled to either a range of from 38% to 60% of their particular salary. The UIF has now put out on their website a calculator. I do mention it lower down. It's a UIF calculator. So if you are trying to work out what your employees, or as an employer or as an employee trying to work out what you're entitled to be paid, would put in the salary into the calculator, and that would calculate exactly what that subsidy is that has to be calculated. But it has now been established that the absolute maximum monthly payment, which is the 17,000, 38% of the 17,000, the maximum payment is an amount of 6,730 Rand. So in effect, every employee that is not being paid is entitled to be subsidized by the UIF based on national minimum wage, and that is worked out to be 3,500 Rand. Now, something, and I've just put this in bold at the bottom of the slide, is that employers can supplement these benefits. So it is open to an employer in this situation to say an employee's managed to get 6,700 Rand relief benefit out of the UIF, they will subsidize the rest to bring them up to a part or their entire salary. In the interest of fairness. Just continuing, there are a few administrative requirements as expected. The company must be registered with UIF benefit. So it doesn't matter how many credits an employee has clocked up, how many years they've been working at an employer. All that has to be satisfied is that the employer themselves are registered with the UIF and comply with a whole lot of paperwork, relatively simple paperwork that can be submitted online, which is encouraging, and it is something that obviously involves payroll, proof of payroll, obviously proof of the company being set up and audited, and bank accounts being set up in a transparent manner. But it is not a very complicated process, and that probably explains why tens of thousands of applications have already been submitted. What has been recognized is that the UIF doesn't have the capability to deal with a complete tidal wave of applications coming in. So what has been arranged that for employers that employ 10 employees or more, they could conclude a written agreement with the UIF. It's really what's referred to as a memorandum of association or memorandum of agreement, and payment will be made to the employer in that situation, who will then disseminate the funds. If there's less than 10 employees, the payment will then just go directly to employees with slightly different, the employer will still assist in setting up and processing the application, but the payment will go directly to employees. And if there's a bargaining council in place, a similar situation will apply. The bargaining council will be required to conclude MOA with the UIF, and the UIF will then pay the subsidies, the benefits into the bargaining council that will then administer those payments. Okay, in terms of procedure itself, I just want to see how my time is going. I know I'm babbling a bit, but trying to get all this information across. The actual procedure itself, and I'm sure if you Google it, it will come up too if you haven't got a pen to make a note of this, but reports need to be just submitted by means of the report of a closure to an email address. It's just simply a blank email, which will then send an automatic response, which will send through the application documents and information required. And as I mentioned earlier, they're relatively simple documents. A letter of authority, a signed MOA, UIF template, proof of payroll for 3 months, and then confirmation of the employer's bank account. Interestingly, and this will be remain to be seen this week is that once the documents are in, the UIF has undertaken to make payment within 10 days and deposit that amount into the employer's account. The employer then has 2 days to transfer that money into employee's account and submit proof of payment after 5 days. And it is anticipated that there obviously will be teething problems, but the idea is that this will create fast relief. It will not be the normal delays that are associated with general UIF claims, which generally take more than 30 days. As far as illness goes, I just want to quickly try and deal with some of this before we run out of time. These recent amendments and regulations also acknowledge that employees are going to be placed in quarantine. A lot of this quarantine is agreed precautionary self-quarantine, where an employee feels that they might have been exposed to somebody that might have been exposed to somebody that might have been exposed to the virus, because we know that the lines of connection are getting longer and longer. All that is required in a situation that an employee is in quarantine, even if they are not quarantined by a doctor, but it's just precautionary self-quarantine, all that is required in order to qualify for benefits from the Unemployment Insurance Fund is a letter of confirmation of this precautionary self-quarantine from an employer. And for the original 14-day period, there's no medical certificate required. I think partly because doctors do not want to be inundated with visits by employees that have potentially been exposed to the virus, but also obviously there's been an encouragement of employees taking precautionary self-quarantine where there are genuine concerns. If an employee qualifies for sick leave in those situations, then they will be covered and entitled to benefits as an ordinary sick leave benefit in terms of the UIF. And that's essentially, they will get their full salary, but off their UIF credits. So they will get their full daily salary. There is a calculation of what they would be paid per day, and it's a relatively simple calculation of taking an annual salary and dividing it by days worked, and they'd be entitled to that. And effectively what it works out to, they'd be entitled to 1 day's pay for every 4 days work, up to a maximum of a year, 365 days benefit. And obviously depending on how long they've worked there will affect what credits they are entitled to, what amount they're entitled to. An employee that contracts the virus, and I know this is down the line because it is the country is managing to keep exposure during the lockdown period as contained as possible, but it is conceivable that there are employees that aren't going to get infected in the workplace, and specifically obviously essential service employees that are now continue to be exposed and run that danger. These are now all regarded as constituting an occupational disease or occupational illness covered by COIDA, the Compensation for Occupational Diseases Act, which will pay full salaries. And I will come to this probably our next webinar, where I'll explain the full extent of the benefits and the process and application process. But those employees that are sick or required to take sick leave as a result of COVID-19 will be fully covered by the compensation fund. So there's money set aside, there's budget set aside, and there's plans in place for covering these employees. Just very briefly on that point, as I've said, COVID's been declared, I've got 3 minutes left, an occupational disease. This declaration was promulgated on the 20th of March. The Compensation Act and the regulations stipulate what is regarded as high, very high, medium and low risk occupations, and they have done this in keeping with the WHO guidelines. So they are in keeping with international standards, and what the provision says is that an employer is obliged to remunerate employees for all days of absence, where in suspected and unknown cases, a registered medical practitioner recommends self-quarantine. So full salary in that situation, but the medical practitioner must state that a suspected virus is acquired at the workplace. So if there's a connection between the virus, the contraction of the virus, or exposure to the virus and quarantine as a result at the workplace, that would be covered by COIDA, the Compensation Act. If there is not, then if the virus or the exposure to the virus occurred outside of the workplace, then that would obviously go through as a sick benefit, as an illness benefit through the unemployment insurance fund. And in terms of what the compensation fund will pay for, they'll pay for medical aid. So they don't mean medical aid as in the fund, they mean for all medical assistance. They'll also pay for temporary total disablement. That's from the date of diagnosis until recovery, and they extend that for a period of 30 days. And in the unfortunate instance of death occurring, they'll also cover burial and pensions for dependents. So it is quite inclusive in that situation. I'm going to skip the last slide and deal with it next week, but just as far as our contact details, I did want us to do a quick poll. I had forgotten to do it earlier in all my enthusiasm. I'm not sure if you're there, Sarah, if you could put up the initial poll questions that I'd intended. The first question is, have you closed down your business entirely or partly during the lockdown? If you could just indicate whether your business has closed entirely, it's partly closed, and whether your business remains open. I'll give you a short while to attend to that. Okay, and I see people are still entering their results, but just as a matter of interest for all of you, 39% of our participants, or those that have entered in their polls, there's more coming in. 41% have closed down entirely. I'm not sure if these numbers are going to still go up. 43% are partly closed, and 16, very lucky percent, have remained open through this part. So certainly from a closed entirely perspective or partly closed perspective, the TERS scheme could most certainly go some way to assist in offsetting the damage, the financial implications. Sarah, perhaps we could just put up the second poll question. Are you still paying your employees during the lockdown? The answer is just simply yes, no, and then a reduced salary. So just waiting to see these results come in. 54% say yes, they are still paying their employees. 17% say no, and 29% are paying a reduced salary. So certainly, my math's not so great, but about 46% are again very capable of getting assistance through the TERS scheme, or salary that those employees would be earning, but one that could be then topped up by the employer. And then if we could just have the third question, just for me, a matter of interest for me is, are you likely to use these benefits, the TERS benefits, or do you see it as going to be a headache from an administrative perspective? Just give it a few more seconds and then I'll let you know the outcome. Okay, so 74% of you have indicated that you would use these benefits, which is very encouraging, because a lot of people originally thought it's going to be an administrative nightmare and not worth going that route. And then the remaining 26% said no. So, all right, well, thank you. Sarah, I don't know if you want to do the last poll question about a bit of feedback on our webinar before we carry on. If you could just please rate the session so we know if we're on the right track or if I should wear shoes. Okay, so thank you for that. Looks like everybody's happy, thankfully, and hopefully we'll come back for our second part of this very exciting installment next week. Once the polls have come down, I'll just move over to the last slide. This is our contact information at University Extended Learning. Please make a note if there's anyone you'd like to contact or any information you need. And then finally, oh dear. Final slide, just setting out our upcoming seminars. That are, as you can see, we've got our second part on the 21st of April, same time next week. But there are, as Sarah mentioned earlier, an entire range of other webinars that might be of interest to you. Where from a labour law perspective, I'm going to be dealing with labour law for individuals on the 5th of May, and then retrenchment in short time, dealing with fallout from COVID-19 on the 12th of May. By then, by the 12th of May, I'm sure there's going to be a lot more information available in this regard. Okay, we do have an opportunity now for questions and answers. This is going to be a technological challenge for me because the questions are going to come up on the screen, so hopefully there's no problems there. Right. Right, how do we go about getting these questions up? Does anyone have a question that they'd like to ask or like to type out?
Tammy, there are some questions over there. Maybe I can read them for you. The first one is from Nolene. If the company has made some payment, do you qualify for the period where there's no payment as a result of the extended lockdown to receive payments through UIF TERS?
Yes, and in fact, that is something I should perhaps have expanded on. If a company has made payment, sorry, there I can find the QAA now. If a company has made payment, they're actually entitled to reimbursement of that payment made. So that's the start. And then obviously the TERS benefits will then be able to claim thereafter directly from the UIF, but either way the employer can get reimbursed the payments that they've already made, but only the amount that they're entitled to from the UIF, or going forward they would then submit claims and get payment directly. I hope that answers that question. I do see quite a number of other questions that have come up in writing. Okay, this copy of the UIF TERS registration details that was on the screen, but what I would recommend is that you just go onto the UIF site. In fact, it comes up in a dozen sites where the registration details, it's just simply a question of sending an email. I can tell you again what that email address is. It's sent to COVID-19 TERS at labour.gov.za. You would just send a blank email to that email address. It's an automated reply, and they will send all the documents to register. Right, so if I could just leave that question. and go on to another question. The second question is that Nolene, you've got lots of questions, that they fall under the MIBCO Bargaining Council. Does payment have to go through the Bargaining Council, or does the employer take this responsibility? It is the responsibility of the Bargaining Council to engage with the UIF in this situation and to draw up a written agreement. They call it a MOA, but it's effectively a written agreement between the Bargaining Council and the UIF. If that is done, payment would then go through the Bargaining Council. If that is not done, then it just remains up to the individual employers to process and administer the payment, the application process and the payment. So either way, the employer has to submit all the documents. It's just a question of whether payment is made to the Bargaining Council if the MOA has been established and set up, or if payment is then made directly to the employer to disseminate those funds. Okay, going on to the next question. Yeah, can we, Sashni, could we still pay part remuneration for employees that are working remotely while waiting for tours? Yes. Obviously, there is an opportunity to partly remunerate, and then even if that partial remuneration, all that the regulations say is that that employee cannot walk away with more than the salary or remuneration that they ordinarily would be entitled to. So that remuneration would then supplement the amount payable by the UIF, or the employer could then get a reimbursement of that additional amount. There is no problem with claiming back, but certainly partial payment is encouraged in that situation. Okay, so going on to the next question, that's AJ's question. We've already made payments for UIF, DSO, and PAYE for April. Do we qualify for claiming this back? There have been directives given by SARS, and I don't want to mislead you and tell you that I know the exact answer. I know that they have allowed for delays with paying PAYE over. They've allowed for a time period for that. However, I'm not 100% sure whether that means that it can effectively be claimed back. At the same thing with UIF, I don't know that they will necessarily allow a reimbursement on those contributions. But yeah, I'm not 100% sure on that. Sorry, AJ. Sarah, there's a question for you. I'm not sure if you'll be able to answer Grant's question. Thank you, congratulations on a great seminar. Thank you very much. Is it possible to get a video, a video replay of this webinar? I'm not sure if that's something you can answer, Sarah.
Yes, we will be sending out the link, hopefully by the end of today, with the access to the whole webinar, and we can also attach the slides. So same way how you received your email with the link to access the webinar, we'll send another one out, and you will have access to the actual video and possibly also the slides.
Okay, well, that answers about 3 questions. So fortunately, I can get rid of a whole lot of questions at once. Okay, let's see. Okay, some of these questions is going to be a little bit of guesswork on my part. As I've said, there's a fair amount of speculation involved with an untested scheme. But the grant, again, as I did answer this question before, if you pay your employees in full, you are entitled to reimbursement. Tandeni, school governing body as employer, how do you go about paying your employees during this period? Well, the same rule applies. Obviously, some teachers are managing to do some online teaching, and that would have to be established as the SGB, whether that constitutes a partial compliance or partial work or full work, in which case they would be entitled to their full salary. If employees teachers are only being paid partially or not at all, if remote teaching is not an option, again, unfortunately, the no work, no pay principle applies, in keeping what I've explained of supervening impossibility, and then there's no obligation to pay, and and then obviously the TERS benefit is an option in that situation. One thing I should perhaps mention, I'm sure quite a few of you are thinking, well, what can we give our employees in the meanwhile, while this UIF process takes its course? UIF plans on making payment in 3 tranches, one after 30 days of lockdown, but for some reason they have indicated they will pay the first tranche this week, and another 30 days later, and another 30 days later. They've set aside 3 months to do this. What one can do, and I have recommended this to a number of people that have contacted me directly, is perhaps do a loan with employees, get employees to sign a loan agreement where amounts will be paid out, but there will be some kind of repayment scheme at the end of the day if reimbursement through the UIF is not forthcoming, or that the scheme effectively does not meet its obligations. Just going up to one of the questions above, you say that there's more emphasis on UIF, and I agree, from government. Will they then unpack COIDA, and can an employee make their own claim if the employer is refusing to submit a claim or is not registered for COIDA? This is something I will get to in more detail in our next webinar, where I'm going to have a very close look at what the Compensation Act is saying and what the steps that have to be followed, the process that has to be followed. But I think there's been more of an emphasis on the UIF because it provides more widespread cover at this stage. Obviously, employees that have contracted the disease at the workplace, numbers-wise, are much less than those of being affected by no pay. But the COIDA provisions are there, and they have been the same COIDA provisions. It's just extending the interpretation of what an occupational disease is. And COIDA has always been a very reliable and very generous option for employees that contract occupational injuries or occupational diseases. If an employer is not registered with COIDA, I would imagine that this might absolutely pose an obstacle, but that is something I will look at and come back to you on next week, because the general interpretation is that the general understanding is most employers will submit some kind of, will have some kind of connection with COIDA. Certainly any of those that are in any occupation that poses the risk of an occupational injury or disease. Okay, Longelo, I haven't got great news for you. The question asked is, does TERS also include those that are self-employed? Sadly, the self-employed have really fallen through the cracks with this. And those are the businesses, the small businesses, the informal traders, self-employed, that are really left without benefit. There are other schemes that have been introduced. Government has put in place a number of support schemes and subsidies for small and medium-sized enterprises. So that is something that needs to be looked at as a possibility to generate some kind of support over this time, while self-employed persons are left in the dark, or certainly left in the lurch. But no, TERS does not cover self-employed at all. Last question, it looks like the last question. Thank you. The last question was just a thanks. I'm so happy to get a thanks and not a question. But thanks very much. It seems like that's the end of the questions. Selinka, Selinka's question, and this is obviously something that will be answered from the UEL side. Sarah, more than me, how do I register to receive monthly emails about these webinars? And at the moment, these emails go directly to my employer. That's obviously an admin issue. Sarah?
Yes. Okay, if you do go onto our website, at the bottom, you can sign up for our newsletter. So I will be sending out a newsletter tomorrow, which features all the remaining webinars we have planned for the rest of the month. So that will go out tomorrow. So if you do want to sign up, you can do that today. And as well as if you keep checking our websites, if you keep checking our social media pages, anything that is new and upcoming, we will post there. So just give us a like on social media and you will see everything that does come up.
Okay, well, that's, I think from the question side, that's all that I've been required to answer. So enough from me, and good luck.
Good. Thanks so much, Tammy. So thank you so much for taking the time out to present here today. And we do look forward to your upcoming webinars. We did mention, the video and the slides will be available on our website. So I will be sending out the direct link to this once it is ready. So you will receive it the same way you received your link to access the webinar today via that MailChimp. I'd also like to thank all of our attendees for joining us and obviously making the webinar a success. Please do take note of the upcoming webinars on the page right now, and we will also send out more upcoming webinars as we schedule them. And then please RSVP to secure your place. You do have to RSVP for each one, because we don't want to just send out there's all different topics coming up, so we don't want to send it out to the same people, and we only want those who are actually interested in those specific topics to RSVP. Yeah, but we also have a few online courses that we're offering for free during the lockdown period. So we're sharing some of our own courses as well as partnering with other organizations in order to provide free access. So do take a look on our website, www.ukznextendedlearning.com, to see what we have on offer. So there's like mathematics from grade 8 to first year. We have visionary leadership, which is a 3-part course which you can do, and we are adding as many more as we can on a daily basis. But otherwise, we hope you enjoyed the session. Thanks again, Tammy, and stay safe, and we'll see you next time.
Thank you. Goodbye.
Bye.